And so the Medicare Advantage plans have exactly the same rights under the Medicare Secondary Payer Act as do traditional Medicare. That's important to understand for a couple of reasons, and I'll explain why in a moment. So the reason why it's important that MAOs have the same rights as a Medicare Secondary Payer conditional payment obligation is because of the double damages provision in the Medicare Secondary Payer Act. While Medicare does not use the double damages provisions, Medicare Advantage plans have used these quite successfully and aggressively to recover double the lien amount if there's a failure to repay the MAO plan, which does happen because these liens sometimes aren't discovered, which is why I said it's a hidden lien. But under federal law, a MAO has exactly the same rights as a conditional payment obligation claimed by the federal government. So the litigation that's arisen in circuits has been over whether a plan can recover double the lien amount. And so in my home circuit, the 11th, Humana versus Western Heritage is the case where the 11th Circuit said yes, an MAO can recover double. That is the law in other circuits. Third Circuit's an example. But in the 9th Circuit and the 6th Circuit, they disagree with the 11th and the 3rd. So you have a split in circuits as to whether there is a ability to recover double. But the risk remains that the plan will try to recover double the lien amount under the double damage provision, and you don't want to be on the wrong side of that claim. The reason why you don't want to be on the wrong side of that claim is because law firms have direct liability and exposure under the MSP. Because remember when I was talking about conditional payments, I said everybody's got skin in the game. Well, law firms have skin in the game. If you miss a Medicare Advantage lien, the MAO or whoever they assign the claim to could come after your law firm for not just the lien amount, but double the lien amount. And they can come after you personally for that. And there are cases, and they're on this slide, where that has occurred. One was a case where we actually assisted a law firm that was defending against one of these claims. That's the Humana versus Paris Blank. You can see it at the bottom. You can Google it. A law firm was sued for double the $191,000 lien amount. Ultimately, that matter was resolved confidentially during litigation, but as a personal injury lawyer or paralegal or law firm owner, you don't want to be in that circumstance. So you really have to make sure that you don't miss one of these liens.